For this evening, we're delighted to have one of the greatest lawyers, present living lawyers, and one of the greatest lawyers that the nation has ever had, by the name of Floyd Abrams, who has just released a wonderful book that the critics are raving about, called Friend of the Court: On the Front Lines with the First Amendment. And what we're going to be doing is a 40-minute conversation interview, and Floyd has kindly agreed to open it up to audience questions so as many people as possible have a chance to question one of the greatest lawyers. So to kickstart it, Floyd, could you please tell us how this very interesting book that's receiving these critical, great reviews came about?
First, I got a call from a legal scholar named Ronald Collins, a professor at the University of Washington Law School. He told me he was interested in doing a book about my views about certain aspects of the First Amendment, different sorts of cases, how I thought the courts ought to analyze First Amendment cases. And he asked me for speeches I'd given and arguments that I'd been engaged in and the like. And I sent him many more than he wanted, I think, but certainly many more than he thought that I had. And he called me up one day, he said, I've got an idea, why don't you publish these? Why don't you put together what you think are the most interesting and continuingly relevant speeches or articles or opinions or the like that you were involved with? And I said, no, too busy. I don't want to spend my time rereading things I said 30 years ago. But it can be very tempting to reread what you write. And I did start to look through articles I'd written and letters I'd written and book reviews I'd written and the like. And so I started to put together a book which sort of spanned 40 years of law and my life in it, but also and only on topics that I thought were still relevant and that people could care about. Sometimes it's hard to make that choice. One of the ones that I found hardest to decide on was whether to put in some material on confidential sources of journalists. And the reason that it was hard was that there hadn't been any cases in a few years now involving journalists who had sources that were threatened by something or other that the government was trying to do or that the courts were requiring or anything like that. But I decided, well, it's an interesting subject. It's got to recur. And who'd have thunk that the same week that my book came out, I was getting phone calls from the press about the administration and the Associated Press and the administration and a Fox News journalist, and whether we should have a shield law protecting journalists and who a journalist was, and whether we should decide who a journalist was or not. I was glad that Chapter 8, tucked in there, had material on that. But in any event, that's how it came into being. The broader way to say it is that I have enjoyed through the years going mostly to college campuses and law schools and talking about various issues, then current, about or dealing in some way with freedom of speech and freedom of the press. And that's, in the end, how the book came about.
And Floyd, tell us, when you first read the Pentagon Papers, what did you think, and why did you think it was so important for the public to have access to what you were able to read?
Well, the Pentagon Papers, for any of you below a certain age, were 21 volumes of material commissioned by the then Secretary of Defense, Robert McNamara. Basically, he asked that it be put together for him in the late 1960s to sort of answer the question, how did we become involved in the war in Vietnam? Now, one could say maybe we should have asked those questions before we became involved in the war in Vietnam. But in any event, Secretary McNamara asked the Defense Department to put together, by putting a lot of scholars together, to write this summary of starting 1945, right after World War II ended, of how the U.S. gradually and then with ever greater speed became involved in the war in Vietnam. And this at a time when the war was not going well, when our entry into it had become very controversial, when trying to get out of it was very, very difficult. And when I was retained in 1971, when the New York Times was provided with a copy of all but 3 volumes of what became known as the Pentagon Papers by a confidential source, the government had advised the Times that if they published this, and it was all classified as top secret, that the government would take steps, that the government would go to court to get a court order barring the Times from doing so. So that's sort of the background of the case. Again, every document in all these volumes was classified as top secret, which is, at least in theory, the highest, most secret sort of material that there is. And when I became involved, the case was so rushed. The government asked for a prior restraint, a court order, an injunction against the Times publishing any more of what was in this study than they had already published, that when you asked me when I first read the Pentagon Papers, I didn't read the Pentagon Papers till the case was over. I read parts of the Pentagon Papers, and those were the parts that the government claimed were dangerous because that was the basis of their going to court. They said if this is published in the middle of a war, it will frustrate our efforts to end the war and otherwise harm national security. And so our job in defending the Times was to persuade the courts that that was not so, or that even if it was potentially so, that it was so important that the press be able to publish information and views and the like about the war, that no injunction should be entered. And that's how it all began, and that was our thinking from the time it began.
And why was it so important that the public have access to it, that it was published?
Right. What was important about it is that it really showed that there had been a great deal of duplicity of our government to our people, mostly in simply not telling them that we were getting more involved and more involved and more involved in the war, and otherwise simply not presenting the full or maybe even anything like a fair picture of the situation there at the time we became really very actively involved in the war. The Pentagon Papers ended in 1968. That was the cutoff date. So the case was in good part historical in nature. The case is 1971. The Pentagon Papers went from 1945 to 1968. And one of the things we were saying throughout was, look, this is history. This isn't what's happening today. You don't have to worry so much that something terrible is going to happen on the ground, that we're going to lose a battle, that we're not going to be able to end the war, whatever. And it's always seemed to me one of the most startling things about it is that we really lost the battle to persuade the Supreme Court that no harm would come. A majority on the court thought it would be harmful, but they weren't sure enough, and they certainly weren't sure that it would be very harmful. And when they put that against the First Amendment, Congress shall make no law abridging the freedom of speech or of the press, they said, you can go ahead and publish it. We don't think we have the power or ought to say we have the power to keep a newspaper from publishing news.
You've been one of the strongest proponents and defenders of the First